I don't believe he's ever had an opportunity to cook for the children, but it's my understanding that is part of his job. He knows how to cook. So I'm assuming he can take care of decent meals for these children and will be given the opportunity to do so.
No hate to the vegetarians out there, but what child chooses to be a vegetarian? My guess is that that is the mother's prescription. Let's go.
Therefore, that special circumstance is not a valid reason against him, and it holds to neither party.
Good.
Obviously, mother has been dealing with that issue throughout the children's lives. The children are not of nursing age. We have a 7-year-old and 2 5-year-old identical twins. The likelihood of abuse or neglect of the child during any parenting time, there is no indication.
Good.
Mom had some concerns that the defendant had a DUI, and that was 12 years prior, or 12 years ago, long prior to her having children with this man.
Wow.
She didn't have just one child with him, she has 3. So for her to complain that is an issue from the past, her testimony as to his other issues that might be more current, no evidence was submitted other than mom's perceptions of that. Dad denied it during testimony, and it was indicative that I don't have any letters from the employer. I don't have anything stating that this is what happens. And since they have such a stretched relationship, it's hard for me to believe that mom knows so much of dad's life other than her own perceptions of what goes on in his life. So I don't find that there is any likelihood of abuse or neglect by the father in this matter, since we are going on parenting time of the father, not really anything with the mother. I will note that any parenting time standard that is ordered by the court does not affect the custodial environment of the children. But there were no CPS investigations or anything that was presented to the court that have any viability. A reasonable likelihood of abuse of a parent resulting in exercise of parenting time. Again, there is no evidence that there was abuse between the two parties. Disagreements, yes. Not liking each other, yes. Not trusting each other, definitively. I will note that Miss Churchill has basically prevented the father from being a father since the birth of these children. From her own testimony, she never really let him alone with the kids from birth. She never allowed him to become a father. She never allowed him to learn how to be a father. You can't set this up and then blame the other side for its consequence.
Now, not only is this woman bringing up a DUI from 12 years ago, and mind you, again, this is a family therapist, but also you're restricting your children with this dietary restriction to not be fed by their executive chef, biological father.
That's not allowable in the law. You don't get to kill your parents and come to court and blame and throw yourself on the mercy of the court for being an orphan. You can't set him up to say, you're not seeing the kids, I'm not trusting you with the kids, I'm not leaving you with the kids, and then complain that he's not involved in the kids. The fact that he was gone for a year, from testimony, I could kind of understand the frustration of the only time you get to see the kids is if it's under your control, ma'am. That kind of control is going to push somebody away. I'm still not giving him any credibility because he did go away for a year. But still, there was also a year that he was fighting for this and has been, and it's been delayed by the court and by adjournments and by other things. So some of that is everybody's responsibility, not just his. But in that time, he also has gotten married and has children living with him, and there are no CPS reports there. There's no complaint and no testimony that there's any problems there.
By the way, I wonder what it's like going through all of those years of law school, all of the study, all of the hard work, all of the money to defend somebody who is actively trying to break up a family or actively trying to keep the father out of the children's life. Actually, I don't want to. I can't even consider that degree of immorality.
The inconvenience to and burdensome impact or effect of the child traveling to and from parenting time, that is a problem. It is a 55-minute drive. The mother has been taking on all of that transportation. That will no longer be. It's going to be split between the parties. Mom chose to take on that responsibility, so some of it may still be hers, but I'm also making the responsibility of the fathers from here on out. And I'm going to deal with that in how I allocate how the parenting time goes. Whether a parent can reasonably be expected to exercise parenting time in accordance with the court order. I have no doubt that once granted, Mr. Tenhofer will exercise every time that's been granted, unless there is a work emergency or something of that nature. Whether the parent has frequently failed to exercise any reasonable parenting time. I have heard no just walking away from parenting time other than that year that he walked away. So no, I don't find that he would fail to exercise parenting time if granted, unless there's an emergency or a work-related problem, of which I would ask that there be a 24-hour notification that I'm sorry I can't make it. Whether the parent is frequently, I just dealt with that one. The threatened or actual detention of the child and the intent to retain or conceal the child. So far, the factors have been pretty well even. This one does go against the mother. The detention is not just the removal of the child or the hiding of the child. It is the restriction of the child. As noted in a previous finding, the mother has restricted this man's parenting time since his birth. The court will not turn him into a sperm donor. It's not going to happen. Continuing his continued supervised parenting time would be an invalidation of laws of the state of Michigan. It is presumed to be in the best interest of these children. He is no danger to these children. You complained at first that he didn't know the children. There are pictures indicating he does. There was a time period he was gone. I will note that he has a home. He has a place for them to be. It is not perfect. Mom has a great place for them to be. I'm not sure who she lives with other than the 3 children. I know that her mother and father are very involved. I don't know if she lives with them or not. There was no testimony as to that. I did meet with the children. I met with them in their individual bedrooms. They are very great children. They are very nice. But the court has grave concerns about how they talk about their father. Really grave concerns. And it goes to a potential interference or just an ability of the mother to not effectuate the father as to being a father.
The term for what the judge is talking about is referred to as poisoning the well, speaking negatively about the father in order to damage the relationship or even just the emotional well-being of those children. Now, this can be very direct, where one parent can just flat out just tell the child that the other parent ain't ish, or it can be covert or very subtle. For example, if you're coming to pick your child up from being with the other parent, you could either be like, hey, so did you have a good time? Or you could be, hey, did you even have a good time? The latter is a subtle way to manipulate the context of the child's understanding. Let's proceed.
Just an ability of the mother to not effectuate the father as to being a father. Some of the things those children said were problematic. There are other words I would prefer to use, but no, they're indicative of a parent that is not facilitating a relationship with the other parent. That violates the inherent rights of the children not to have either parent disparaged by either party or third parties. I am gravely concerned about the ability of the mother to make sure that the father becomes a father. You chose him, not me. And sir, don't complain about her either. You chose her. So I have concerns about her facilitating this, and under the threat or actual detention, the detention would be the inability to facilitate that relationship. So at this point, I do find that there is no clear and convincing evidence. There is not even a preponderance of the evidence to prevent the father from having normalized parenting time. Now, that doesn't happen automatically. Some judges would just say, look, next weekend he gets every other weekend starting next weekend. We're not going to do that. This court works in the best interest of the children. So let me see if I can move this. I know the father tried to get the children to meet his current wife, which should have easily been done. Again, the warning that was given to you on June 3rd was, you control this or I will have to. I gave you the opportunity, and it's been more than a year, and this should have only taken 6 months.
It's my guess that this man stopped trying for a year because he's dealing with a soul-sucking vampire. It's emotionally draining. And some men just give up. I mean, not only are you dealing with a demon woman that is stopping at nothing to alienate, but then also a court system that assumes that she is the better parent. But it's great to see not only this guy get back in the fight, but also this judge completely dress her down. Fight for y'all children.